So thanks a lot, Taxmann, and my esteemed attendees for sparing this time to attend this webinar. And today, we know the show cause notices under the GST are at the peak, and it is the most appropriate time when we look at the entire gamut of legal provisions within the GST law and outside of GST law, particularly related to a show cause notice. And as we are aware that show cause notices for 1718 were issued and kind of adjudicated upon as well for Section 73. For 1819, they are yet to be issued, are being issued. And for 1920, they would be very soon to be issued. So it is the most appropriate time for this topic to be looked at, how we address, how we respond to the show cause notices, and how we can uh, help our clients and successfully defend the allegations made to us. Uh, so let's begin with the first uh, issue that comes to mind is what is a show cause notice and why it is important, what is the relevance. We can go back to a Latin maxim, audi alteram patrum, which essentially says that no one should be condemned unheard, which is also incorporated in the principle of natural justice that has been upheld by our courts in various proceedings right up to the Supreme Court. In fact, Supreme Court in one of the matter has said that principle of natural justice is kind of a fundamental right as it has been incorporated indirectly in Article 14 of the Constitution. So it is so important that the principle of natural justice is adhered to by the adjudicating authorities, which means that you have to hear the other party. Our Section 75(4) and 76(5) of the CGST Act specifically provides that opportunity of hearing is the prerequisite before passing an adverse order. So we all know a show cause notice is to be given. But the question is, what are the allegations? Against whom? What legal provisions violated? What is the demand? All these questions. Now, then it says that you have to be heard, but heard regarding what? What are the allegations? Against whom these allegations are made? You have to tell me that which legal provisions I have violated. Only then I can make an effective response. Now, a very landmark decision of the Supreme Court in the case of Brindavan Beverages, where the Honorable Court has said that SCN is the foundation on which department has to build up its case. So this is the foundation. Unless something is not there in the foundation, it cannot be there. So SCN goes to the foundation of any indirect tax proceedings, and that has been upheld by Supreme Court time and again. So you can imagine the kind of importance SCN gets in indirect tax litigation. Supreme Court in the same case has also had that the allegation in SCN must be specific and not vague, because SCN is the foundation of principle of natural justice. The authority has to hear me before passing an order. Now, unless the allegations are specific, they provide me complete details, only thereafter I would be able to defend myself or give an effective response. Only thereafter the opportunity of or the principle of natural justice can be said to be upheld in the right spirit. So Supreme Court has said that if the allegations in the SCN are not specific and are on the contrary vague, lack details, and unintelligible, that is sufficient to hold that the noticee was not given proper opportunity to meet the allegations included in the SCN. And on that basis, the Honorable Supreme Court has quashed the show cause notice in this proceeding, and consequently, the order passed there. So you can imagine, in case of a vague SCN, the entire proceedings can be quashed by the Supreme Court. So first of all, whenever you get a show cause notice, you need to be you need to carefully examine whether it has all the required details which enables you to file an effective response. Going further, now again, the SCN should not be issued on assumptions and presumptions. Supreme Court said that you cannot issue a show cause notice on any assumption or presumption. It has to be based on solid facts. Only you draw the inferences on the basis of certain entries in the ledger. Supreme Court nothing to it. It's not sufficient. You have to have a sufficient evidence. You have to have sufficient facts, and on the basis of facts and the evidence, only thereafter you issue a show cause notice to a party and ask him to provide a response. But even having done that, you still need to have an open mind, because you are only giving a show cause notice. You are not adjudicating yet. You have to be an open mind person. It should not be biased, and you should be ready that if the authority has, if the assessee or the respondent has provided you with this decent reply, convincing reply, you should be able to accept that reply and drop the proceedings. If you are issuing a show cause notice with a closed mind, where you say that no, my mind is already made up, I have kind of in my mind already declared this person guilty for any tax evasion, for any other matter, effectively, are you really giving him an opportunity? In that case, it looks like there is no opportunity. It is only a eyewash, and on that basis, the entire proceedings can be quashed. So Supreme Court again, time and again has said that SCN has to be given with an open mind, and thereafter only the proceeding should proceed. So these just couple of cases on the SCN should be able to tell you that what is the importance of SCN. In our entire jurisprudence of indirect taxes, SCN holds a paramount importance. And therefore, it is very important for us to understand really what SCN entails and how it has to be handled. Now, we talk about SCN, particularly the most relevant sections in the GST law are section 73 and 74. And probably the largest chunk of show cause notices to be issued under the GST law would be in these two sections only. So it's very important for us to understand these two sections. And the SCN in 73 or 74 can be issued after an inquiry or an assessment or a scrutiny or audit or special audit or investigation, search, seizure, or any other source. Because the section 73 starts with saying where it appears to the proper officer that. Now, it should appear to proper officer. It's not appearing to him out of a blue, out of just his gut feel, but on the basis of certain material, which of course he may or may not disclose to you at that point in time. But if he want to rely on that, he has to make it a part of the show cause notice. Now, when it appears to proper officer that either tax has not been paid or short paid, or erroneously refunded, or input tax credit wrongly availed or wrongly utilized, then he should serve a notice on the person chargeable with tax. If he is alleging fraud or willful misstatement or suppression of facts to evade tax, the notice would be issued under 74. Other cases, it would be issued in section 73. And the amount of tax along with interest and penalty would have to be specified. But these are not the only sections under the GST law where a show cause notice will be issued. These are the few of the sections where show cause notice will be issued, which are not culminating in 73, 74. So like TCS, tax collected, not paid, penalty for certain offenses, penalty for all, general penalty. Lot of provisions are there for which SCN would be issued and which may not get culminated into 73, 74. So we need to be, when we are studying the provisions for SCN, we cannot confine ourselves to 73, 74 only. And we need to be mindful that there are other provisions as well where a SCN can be issued. Where we have been talking about, a lot of talks are being held for about this time limit for 73, 74. Even the writ petitions have been filed where the extension of time for 73, 74 has been 73 has been challenged. But please keep in mind, these time limits are for 73 only. The time limit prescribed under 7310 and 7410 are for those sections only. For other provisions, generally, there are no time limits have been prescribed. Where there is no time limit has been prescribed, the Supreme Court in number of cases has read that notice has to be issued within reasonable time. If no time limit, doesn't mean the authority can come back to me after 10 years and issue me a notice. That notice has to be issued within reasonable time. And what is the reasonable time? It is to be decided on a case-to-case basis. The Supreme Court said the time limit of 3 to 5 years appears to be reasonable, and that 3 to 5 years is also consistent with the provisions of the GST Act. So wherever this time limit has not been prescribed, one can assume that if a show cause notice has been issued within 3 to 5 years, that is still within reasonable time. Now, next question is that who is authorized to issue show cause notice? The law says the proper officer has the power to issue SCN under sections under 73 and 74. A proper officer is defined under section 2, subsection 91. Please keep in mind, 73 says the proper officer. Section 2, subsection 91 defines proper officer. Section 3 and section 4 empower central government and the board respectively to appoint officers. Section 5 empowers officer to exercise powers, discharge duty under CGST Act. Both government and the board have issued notifications, circulars, fixing territorial limits, functional limits, monetary limits, everything. Some of the officers which are like posted in DGGI or other investigating branches, they have all India jurisdiction and they are authorized to issue SCN, not basis within their territorial jurisdiction, but on all India basis. Are they valid show cause notices? Particularly, the issue has come because of the landmark decision of the Supreme Court in Canon, India, which was in case of customs law, but the principle can be applied here, where Supreme Court said that the law has used the word the proper officer and not a proper officer. So the proper officer means the person who has already originally adjudicated the bill of entry in that particular case. Now, who is going to be the proper officer in case of GST? And that issue has to go to Supreme Court as yet. And therefore, we do not have an answer to this. But it is in our respectful submission, a very, very important point. And wherever there are significant stakes are involved, we must take this as a ground in our show cause notice. And therefore, if a final decision on this point is in favor of the SSC, then the SSC should be able to take the benefit if that ground has already been taken. So this is a very important point to be keep in mind. It goes to the jurisdictional issue, and we are not aware as yet how the Supreme Court will respond to that. But it's very important point for someone to keep alive at this stage. Then there has been very discussion about manner of service, which has been prescribed under section 169 of the Act. Rule 142(1) says that along with the SCN, a summary thereof shall be provided electronically in form GST DRC 01. Now, when a summary has to be provided along with the SCN and summary has to be issued electronically, the natural reference comes that the SCN also has to be issued electronically. But Section 169 provides various modes wherever the SCN can be issued. As I mentioned, now this has been examined by courts, and we come to that. But staying with 169, it says that every decision, order, summon shall be deemed to have been served on the date on which it is tendered or published, or copy thereof is affixed. If it has been sent by a registered post as a speed post, it shall be deemed to have been received by the addressee at the expiry of the period normally taken by support. But it says unless the contrary is proved. So it's a presumption in the law, but it is a rebuttable presumption. If the assessee is able to prove that I have not received, and how he can prove a fact which hasn't happened, he has some kind of a inward register, or if he is able to file an affidavit, because actually the SCN was not served, then that is an admissible evidence. And therefore, it is extremely important to record when the SCN was issued and how it has been issued. And we'll come to that in a bit later. The Honorable High Courts, in at least 2-3 cases, they have already mentioned the SCN can be issued only electronically on the common portal. Now, this creates a challenge for some people, but this is where the courts have held. And as we are aware, the GST is extremely technology driven. Everything is through GST portal. And therefore, you file returns twice a month on GST portal. You download your GST at 2B every month, do a reconciliation. So it is now effectively, it's not an excuse for anyone to say that he was not aware, he did not see his portal, he is not visiting his portal on a regular interval. That kind of an argument is actually is no more available with the SSC. So it is very important that the portal must be visited regularly and see any notice is issued or not. Now, there was an issue earlier because there were no notice was being uploaded under the head view notices. It was going to additional notices. And the Honorable High Court in Savari Infra said that this is wrong. You need to fix your technology, and therefore the notice should come in view notices and not in additional notices. Although the court has not quashed the notice, but they directed that it should be the technology issue should be resolved. My suggestion is please look at both. It doesn't take too long. It takes a minute. Look at view notices, look at additional notices as well, because now challenging, we have not received the notice, going to appeal, getting it remanded. It's unnecessary effort which can be saved. Notice has to be served on authorized person, and that is a legal position upheld by courts for quite a long time. In this case also, Mamaya, the Honorable High Court has said that service of SCN on the accountant who was not carrying the authorization is not a valid form of service. So whenever service is alleged by department, please be careful whether it was served to the right person and can department establish a valid service. Because if there was not a valid service, then probably it could be time bar as well. What are the essential particulars of a SCN? It has to have an introduction of the case. It has to have a factual statement. It has to appreciate the evidence along with RUDs, that's a relied upon documents. It has to have a discussion on a legal framework, statement of charges. So what are the allegations against me? Then it has to have a discussion on the limitation. And if they want to invoke 74, they have to specifically mention that what are the grounds for invoking extended period. Calculation of tax and any other amount due, that has to be clearly mentioned. They have to clearly mention what is the designation and the address of the authority who is going to adjudicate, to whom I have to file my reply, and what is the time period for reply. All these are very, very essential particulars that has to be there in a particular show cause notice. Now, what is the general principle of show cause notice given under Section 75? Because the 75 is kind of a procedure. It's a summary of various legal principles upheld by Supreme Court in various cases. And the 75, few of the points that mention that if 74 notice has been issued under 74, which we know goes to 5 years, and the appellate authority said that 74 is not invocable, then you cannot say the entire show cause notice goes for a toss. The 75 section empowers the proper officer to determine as if the notice was issued under 73(1). But at the same time, if the notice was issued beyond the time of 73(1), and tomorrow the appellate authorities or tribunal held that the invocation of 74 was not valid, then the department doesn't get anything at all. Because for adjudicating under 73, the notice should have been issued under 73 only. Okay, so that's very important. Keep in mind, the proper officer, the law says, in my view, it was not required to be said. It's a very settled principle. The proper officer shall set out the relevant facts and basis of his decision in the order. Our entire jurisprudence is based on the authorities passing a speaking order. Supreme Court has said time and again, authorities have to pass a speaking order so that the respondent can apply his mind and explore his legal options, and is aware of the basis of which or even the courts become aware of basis at which this has been passed. Amount of tax, interest, penalty cannot be more than what is specified in SCN. So we go back to Brindavan beverages, where this SCN is the foundation. The amount of tax, interest, penalty in the foundation cannot be more. You cannot have a foundation of a 3-bedroom house and build 6-bedroom house. So the foundation really confines the area within which the SCN and the subsequent proceedings would have to take place. And this also says that no demand can be confirmed on grounds other than the grounds specified in SCN. Extremely logical, very well settled by numerous decisions, but it's nice to have it incorporated in the law so that the disputes would be less. Okay, so adjudicating proceeding shall be deemed to be concluded if the order is not passed under 73(10) and 74(10). Okay, where any penalty is imposed under 73, 74, no penalty for same act or omission would be imposed on the same person under any other provision. So you cannot have 73 and 122 being applied simultaneously. So that's not valid. That's specifically provided. Now, these days there have been very, very heated debate that whether DRC-01 has been issued, DRC-1 is to be issued, what is summary, what is show cause notice, and there are very, very divergent practices, I would say, between the state officer and the central officer. So courts have had a summary of SCN issued is not proper. You have to have an show cause notice. In fact, Rule 142 says the summary along with show cause notice has to be issued. So you cannot expect an assessee to respond to only a summary without going through the entire detailed SCN. There is no substitute for the detailed SCN. Amount of demand has to be determined. If SCN fails to provide which are the provisions which have been violated, it has to be quashed. So SCN has to be very, very clear, very specific. The government has said that SCN cannot be issued without then, it's a circular says. But these days there is a huge debate about the signatures, because we are seeing a lot of system generated notices where there are no signatures, not even digital signatures. And department has argued that we have uploaded the SCN on the portal and therefore signatures are not required. The court has said uploading of SCN is a manner of service. It is not a substitute for signatures. or digital signatures. So if there is a SCN you receive without signature, please challenge that appropriately, because it is not a valid document. It is not a valid SCN at all. And there are number of decisions to support that. Who is to adjudicate? The adjudicating authorities have been notified. We can go back to our discussion on the Canon India under 73, because it is the proper officer who has to adjudicate. But in couple of cases, the courts have held the same person who is conducting search, who is doing seizure, cannot adjudicate SCN. So because you cannot be a prosecutor and a judge in the same case. That's a fundamental principle that has been applied by the courts in these cases, and we'll see how it pans out going forward. Now, when you look at the documents, there is something called RUDs, and the people who are dealing with central laws like service tax excise, they are very well aware. Not too much prevalent under the VAT laws, but under the general common parlance of the jurisprudence, any evidence which an authority want to use against an accused, it has to be shared with. So on that ground, the relied upon documents, whatever are relied upon in issuing of show cause notice, has to be provided. They might not be asked by taxpayer, but it is the duty of the notice issuing authority that the RUDs should be provided. The cross-examination of witnesses relied upon in SCN, that should be examined, that should be asked for, and non-relied upon documents. The department give you a relied upon document, but they don't give you non-relied upon document, although the circular say that they should be returned forthwith, but generally they are not provided. It is also possible that non-relied document, which department has found not to be relevant, could have something which is in your favor. And therefore, it is extremely important that you immediately write a letter to department. Please provide me non-relied upon document, because my response cannot be prepared unless I have that. The Allahabad High Court decision supports you on that, and you can proceed on that basis. Now, the most important is how you draft the reply. So please keep in mind, it is the first representation to the department, and it therefore holds paramount importance. Extremely carefully record the manner and date of receipt of SCN. The envelope and the speed post tracking sheet must be preserved. Verify DIN on the base on the CBSE site. Verify signatures. As I mentioned earlier, uploading on portal is not a substitute for signatures. Examine all RUDs and refer to in SCN. If RUDs are not available, immediately write a letter seeking RUDs which has not been supplied. Also ask for non-relied upon documents mentioned. Please carefully verify the facts. Do not say that SCN has mentioned certain facts, you have to take them for granted. In my experience, the errors are frequent and sometimes deliberate as well. I have seen where department authorities have switched from inches to feet and feet to meters. The quantum goes 3 times, 4 times, 10 times. So please be very, very careful. Corroborate the facts with the relied upon documents. And if there are any incorrect fact mentioned, please counter them in your first submission. Because if you do not counter the facts, the higher courts will not allow you submission of additional facts or additional evidence. They say you're not counter, so these are the admitted facts, and that might hurt your case extremely badly. So checking the facts, countering the facts is extremely important. Okay. Ask for the cross-examination of witnesses examined and who have supplied the relied upon documents. The request for cross-examination should be very clear with reasons, because the courts have had, it is not a matter of statutory right, but you have to explain, make a submission that why you need the cross-examination and why your right to defend yourself is hampered in the absence of those cross-examination. So tomorrow you can say that I have applied to ask for cross-examination. I have given reasons for such a request. And if authorities are not able to, have not been able to provide me cross-examination, I cannot be fault with. I was not provided enough opportunity to defend myself, and therefore this entire proceeding is violative of natural justice, liable to be quashed. But you have to make a case for seeking the cross-examination. Our section 75 provides for personal hearing. I will come to that, but definitely you have to make a specific request. The personal hearing, even if you do not intend to, still it gives you a reasonable time. Some additional facts may come to your notice. Some additional judgment may in your favor might come to your notice. Some additional grounds you may counter. So please make a specific request for personal hearing. When personal hearing notice comes, it is still your choice, go or not go, but still apply it. In what we were seeing, that once you say no to personal hearing on one occasion, and if the case is adjourned, the authorities used to treat that you have refused for personal hearing. The Odisha High Court said that he said no to personal hearing only for that particular occasion. If the case has been adjourned, so that no cannot be said that it has been no for all adjournments. So he said no to personal hearing on one occasion. He may come for personal hearing on other occasion. So it's a duty of the authority to give you personal hearing. So you can say, even if you said no, they are bound to give you personal hearing or ask you for personal hearing at the next time. Now, very important, how you structure the reply. Your reply should be structured on following lines. First is submission of jurisdiction. If the SCN has not been issued by officers of your range, your ward, you can say he is not the proper officer, and in view of canon in India, this SCN is without jurisdiction. Say that all the submissions hereinafter are without prejudice, challenge the jurisdiction in the first sentence. Then we are seeing a lot of computer generated notices. Section 73 say where proper officer is of the opinion, he believes, he feels. Have we shifted the role of proper officer to the GSTN? GSTN is not a proper officer. So we can say proper officer has not applied his mind. It is a system generated notice. Hence, it is also not been issued by an officer authorized by the law. It is also without jurisdiction. It is on a much stronger footing as canon India. Then you come to next on merits. You address, make the submission on facts. You make submission on merits. You challenge facts. You challenge merits. That then you come make submission on limitation. Why the extended period should not be invoked in your case. Everything was declared. It was on books of accounts. Due returns were submitted. All of that you can make. You can make then submission on the computation of tax, whether the amount of tax has been computed correctly, or the assessable value was collected correctly, whether they have correctly applied the rate. And you can, if there is a issue of non-tax payment, you can ask for cum tax benefit. He said, my price was inclusive of tax. At least your output tax liability might get down by 18%. If 18% is the GST rate. Next, you come to the submission on penalty and your submission on manner of service of notice. If the notice was not properly served, you make the submission on that ground as well. So these are the few grounds, maybe around 8-10 grounds, on the basis of which your reply should be structured. So you have to at least tick these boxes. You may have more grounds, but these are the minimum boxes that you should tick, and your reply should be structured on these lines. Submitting the reply to the SCN. If you received a notice on the common portal, it has to be submitted on common portal. But we are aware the portal has its own limits in terms of number of attachments, size of documents. What do you do in that case? You submit a physical reply to the officer. We have seen a number of cases, officers say we will not accept the reply. Because they say you submit on portal only, will not accept it. Okay, if that is the case, send it by speed post. Keep the tracking of the speed post in your record. Proper delivery was done. Keep it with you. That is a sufficient compliance. Tomorrow you go to a appellate court, you can say it was submitted to the authority within time. He was bound to take notice of that because of the limitation of the portal. Now we come to the issue of frauds and submission. There has been settled legal principle that if the department is challenging you, alleging fraud or suppression of facts with an intent to evade tax, onus is on them. There is a clear case of Constitutional Bench of Honorable Supreme Court in Ambalal versus Union of India, where court has clearly said that onus is on the department. Onus is on prosecution and it rarely shifts. So please challenge that. You don't have to prove your innocence. It is the department who has to prove your guilt. The moment you start thinking on those lines, your defense would become stronger. So you have to counter, you have to create a doubt in the establishment of the department, and your case is done. You don't have to prove that you are not guilty. You have to prove they have not been able to prove their case. And mere non-payment of tax is not suppression. There can be bona fide belief. Okay. The words used in the law of frauds, willful misstatement, or suppression of facts to evade tax, these are strong words. These words require some positive action. You have to do a fraud. Fraud is not a mistake. Willful misstatement is not an innocent statement of a wrong fact. Suppression, these are all words which require a positive action. So some deliberate and positive action is must on part of taxpayer. Only then these grounds can be challenged. If you wanted, if there was a bona fide belief, you were to file a return or make payment, you could not. The transactions were recorded in the books of accounts. These days, our entire data is already with department. I have my e-invoice is there, my e-way bill is there, my GSTR 2B is there. So my input, outward, everything is with the department. So where is the question of suppression? Everything is with you only. So for them to allege 74, it is extremely difficult, and you should keep that in mind. Suppression is not applicable when question of law is decided by Supreme Court or tomorrow clarified by CBIC. Because where there is a bona fide dispute, there is an interpretation of law, there is no suppression. I have a view, department has a view. Tomorrow, which view is upheld by Supreme Court, nobody knows. So how can department allege me that I have suppressed facts? It was a bona fide belief. Okay. Tomorrow, Supreme Court might have gone in my favor or in your favor. If the bona fide belief is there, if the communications are there with the department, then it is extremely difficult for department to establish that there was a suppression of facts. Please keep that in mind while challenging notices under 74. Personal hearing 75(4) provides that where request is received in writing or an adverse decision is to be made against a taxpayer, personal hearing has to be granted. You cannot get more than 3 adjournment, but you can still make additional submissions during the personal hearing. So personal hearing is extremely important. The courts have held personal hearing is to be mandatorily afforded. But in one of the cases, Allahabad High Court has said that if no reply was submitted, 75(4) is not retracted, and hence opportunity of hearing was not required. I respectfully do not agree with this view, but this is a judgment of a High Court. Okay, I may agree, I may not agree, but this is a judgment of a high court. We have to take cognizance of that, and we need to be careful that I file a reply and I seek an opportunity of being heard before passing an order. At least I can go and make my submission. I get little more time to prepare, because even if I'm not able to prepare a reply and submit any reply, just one letter seeking a personal hearing will give me additional time to prepare my reply and make my case to the authorities. So these are the few points that we have not gone into the merits, we have not gone into the factual, but these are the broad points which you need to keep in mind in SCN. This topic is extremely large, but given the time, I try to kind of run through. Pardon me if I was kind of speaking a little faster, but the way the length and the breadth of this topic is, probably we would require half a day or a day to do justice to this topic. With this, I conclude my discussion, and I should be able to take any questions that you have. I see questions in chat box, and sir, request you to please share the PPT. I think it has been already mentioned, Mr. Shah, that by Taxmann that the PPT would be emailed to you all. So don't worry about it. Any questions? Okay, the question is being asked. Officer is not giving how he charged interest penalty in SCN and in the order passed. The amount is there, but the calculation not given. Is this correct? Definitely, it is not correct. And you need to challenge the computation. You need to challenge the appeal that this computation was not provided, and he needs to provide you with the computation. But the order has been passed. You need to challenge it in the appeal. While going into appeal, there is no opportunity for you to ask for that calculation. You can make your ground, but the officer also has no ground for or no opportunity for giving you that calculation. So in that case, what you can do, if you have your own calculation which you believe is correct, and the officer has charged more interest or penalty, you can provide your calculation during the appellate proceeding, and you can challenge the amount of interest and penalty which has been there in the order. What is your take on late fee penalty? I'm sorry, I'm not able to understand this question. Please ask again in little more elaborate form. We go to the revenue neutral case. Revenue neutral case is where you are able to avail, or the other party is able to avail the credit. So you have charged tax and the other party is able to avail the full input tax credit. So this is where we say it is a revenue neutral. If I charge less tax, the other party is able to avail less input tax credit, and therefore my charging of lower tax is revenue neutral because it does not result into any loss of revenue to the government. Now, revenue neutral case is applied, is a very important concept in our jurisprudence. In cases of like Northern Operating System, in revenue neutral, the Supreme Court has said revenue neutral and hence extended period cannot be invoked. But in certain cases, so it is to be decided on a case-to-case basis, but it's a very important tool for you to argue against the penalty and against the uh, extended period, if not for the interest and tax liability. Whether officer is required to prepare and provide calculation for the allegations made in the notice, like mismatch of e-way and value of turnover. Definitely. See, as I mentioned, you can go back to the Brindavan beverages. The officer is required to provide you the calculation. Now, these days, what is happening? They are saying there is mismatch in your GSTR 3B and 2A. Please pay me tax. No invoice-wise reconciliation is being provided. In my humble submission, all those allegations are incorrect. The officer is required to provide me an invoice-wise reconciliation that these are the invoices which are appearing in GSTR 2B, or which you have taken credit or not taken credit. If he has no basis, because in 3B, I'm not providing him detail, the officer can ask those details from me. He can make an inquiry. Nobody is asking him to prepare a show cause notice sitting without doing any work. He can ask me an inquiry of details. He can ask me the backup of GST or 3B and do a reconciliation, and only thereafter he should be able to uh, issue a notice. In e-way bill and value of turnover in GSTR 9, he can ask you information. If he is not satisfied with the information, only thereafter he should go and issue your notice. And in that notice, since he has done an inquiry, it would be a very intelligent notice. Otherwise, uh, it would be a defective show cause notice, and if you can litigate it, it can be quashed. If tribunal is of the view that section 74 cannot be invoked based on subject matter and fall under 73, but period of limitation is crossed, what shall be the treatment there? If the period of 73 is crossed, that means the notice was issued under 74. After the period of 73, the entire show cause notice will be quashed and no liability will survive. There is a circular on that point. I'm not specifically remembering that. I think circular 175 or something, but there is a elaborate circular on 74 and 75. You can check it. Otherwise, send me an email. I'll provide you that. If tax amount is paid after issuance notice under 73, inform DAJ before passing whether penalty would be applicable. If you pay tax and interest under 73, then penalty will not be applicable. But if you only pay tax and no interest, then penalty could be applicable under 73. Sir, if a GST audit is completed for a period, can GST department can issue same queries again? It's a very fact-specific issue. If you say that GST audit was completed and those queries were addressed in the GST audit, nothing stops from department from asking those queries again. But in that case, they have to confine and they have to issue show cause notice within time limit of 73 only. They cannot do that after going through the GST audit, understanding the queries, not issuing at that time, again ask you queries and invoke 74, because they were aware of this at the time of GST audit. They decided not to issue, and therefore, if they want to issue notice on the basis of those queries, they have to issue under 73 only. Next is the officer has passed order under 74 and we paid tax interest penalty without disagreeing with section 74. The penalty will revert 25. Order of the Supreme Department penalty recovery 100%. Can we request to consider the proceedings under 73 instead of 74? Can we challenge application of 74? See, this is a very fact-specific question. There is a settled principle of law that a legal ground can be raised at any point in time. It has been settled that the invocable of extended period of limitation is a mixed question of facts and law. And therefore, I think you should take a challenge, and the department has gone into appeal. In that appeal, you should challenge the 74 itself. But it's going to be complicated because you have not filed an appeal. So it is a departmental appeal, and there is also a legal principle that the petitioner cannot be worse off as compared to the original order. So if the appellate authority were to accept your version, that means department would be worse off by filing appeal. So it looks difficult, but if the quantum is sufficient, I think you should take a chance. If the GST audit is completed after 180 days and can we challenge the High Court? Should we challenge an appeal? No permission. I think you should take, if GST is completed after 180 days. See, it is very difficult to establish. that because 180 days is from the date when all the queries, all the answers were given. Department asked so many questions that which are practically almost impossible to comply with. But if you are confident that all the things were given and after 180 days they have issued, you can challenge that in a writ petition in a high court, because it is there then beyond the limitation period, and therefore it is challengeable in the high court itself. You always have an opportunity for appeal. High court at best can also send you back for alternate remedy, but if you have a good high court, that can you can take a chance. Can state officer issue inquiry letter of Judicial Commander Center for ITC related? See, both the states and the central authorities have been empowered to investigate the matter. So if it is a matter of investigation, both parties can initiate investigation. If it is only a matter of routine inquiry, then not. Okay. Date of commencement is mentioned in ADT 2, but date of completion is not mentioned in ADT 2. I think this is very factual. So look at your facts in little more detail and then take the chance. I think all the queries, okay, all the queries have been addressed. I would request Taxmann to take it over now and perhaps conclude the session. If there are any queries even after this session, I would be happy to answer that. Okay, last query has come that state authorities are not mentioning DIN in SCN. I could not find, so there is no circular. Only in case of Supreme Court has issued an advisory for state authorities to mention DIN in SCN. Some of the state authorities have started it. Some of the state authorities are yet to start this. But for central SCN, DIN is mandatory. For state, it is not. If the tax amount mentioned in the SCN of GSTR1 or GST wrongly calculated, can we give our calculation, let the department know of their calculation, let the department know that their amount mentioned is not correct? Absolutely. If the department has given incorrect information in SCN, you must provide the correct information. Otherwise, they will raise demand on the incorrect amount and you would have to pay additional pre-deposit and all that stuff. We received a notice for difference between e-way bill generated wrongly versus GSTR for 1819. If it is a clerical error and we declare correct 1 and 9, how to provide an effective reply to this? See, the difference between e-way bill and GSTR is not an offense per se. The officer has to say that there is a short payment of tax. Under 73, it is a short payment of tax. So if the tax has been paid correctly, then there is no offense. You should explain them. And if they issue a show cause notice, then respond to that show cause notice based on what is mentioned in the essay. Can department send SCN directly before issuing ASMT 10 or the intimation in GSTR 1A for the same issue? There is a recent High Court decision where they said that ASMT 10 was mandatory. They've only issued a notice, but there's only one High Court decision. And intimation of DRC 1A, the rule has been amended to replace the word may instead of shall. But for 1718, you can argue, you can challenge the SCN on the basis of DRC 1A was not issued. Okay. Thank you very much.